I want to take just a second to thank Wayne State University, the law school, for supporting this, and certainly Jessica Bukowski for organizing this whole thing and getting all our speakers here, organizing everything, and making this all come together. Thanks, Jess. For lunch today, I have the honor of introducing Karen O'Keefe as MPP's Director of State Policies. Karen manages MPP's grassroots and direct lobbying efforts in all 50 legislators. Karen has worked at MPP since 2003 and played a significant role in MPP's successful medical marijuana ballot initiative in Montana in 2004 and was heavily involved in passing MPP's medical marijuana bill in Rhode Island in 2006. Karen has managed MPP's state legislative department during victories in Rhode Island and Vermont to add regulated medical marijuana dispensaries, the passage of a medical marijuana defense and study committee in Maryland, and a successful campaign to make Delaware the 16th medical marijuana state. She is responsible for updating MPP's model medical marijuana legislation, which formed the basis for laws in Arizona, Delaware, Montana, Rhode Island, and here in Michigan. She's the primary staffer working with the local grant recipients to draft and enact measures making marijuana offenses the lowest priorities in 6 cities in California. Please help me in welcoming Ms. Karen O'Keefe.
Thank you, Michael. Thank you to Wayne State for hosting this fabulous symposium, and to Jessica for all your work, and to all of you for being here. Good afternoon. So, today I'm going to talk a little bit about the history of marijuana prohibition, and then I'll get into what the landscape looks like now in terms of current laws in states that decriminalize the possession of marijuana. We'll look at some statistics related to usage rates, marijuana arrest rates, and then we'll look at different states' medical marijuana laws. Finally, I'll get into what we might expect later in 2012 and beyond. And at the end, we'll have some time for question and answers. I didn't plan to talk a lot about the Michigan medical marijuana law because I know there's a later panel on medical marijuana, but there will be time in question and answers for that as well. So first, let's take a look at how we got to where we are today. Only a century ago, marijuana was not illegal in any state in this country or federally. It wasn't used very widely at all for non-recreational use. Hemp was used in, the fabric was used. But it was used for medical use. Tinctures, which Professor Vivian showed us how to make earlier today, were sold by pharmacies. I'm glad I don't have to explain what tinctures are, since you all know now. And prescribed by physicians, only from about the 1850s until the mid-1900s, about 1940 or so, it was in the pharmacopoeia. Then states began to ban marijuana possession in the 1910s for non-medical use. States went first before the federal government. There wasn't a whole lot of debate. This was the same time when states were also enacting alcohol prohibition laws and outlawing the non-medical use of opiates and narcotics. The little discussion that there was, use increased a bit in the 20s and 30s, but was still relatively rare. And a lot of the conversation made it sound like marijuana was linked to crime and violence, and there were a lot of sensational, lurid claims about marijuana being linked to violence. And then, as we've heard earlier, Congress acted in 1937. It didn't outright ban marijuana, as we've heard. Instead, it enacted the Tax Act over the objections of the American Medical Association, which thought it would stymie the medical use of marijuana, and which it in fact did. You can see a quote there from one of the chief advocates for prohibition. Gives you some idea of the content of the dialogue. So fast forwarding to the law that we have in the books today. As you've heard, marijuana is a Schedule I controlled substance, meaning that in the eyes of the federal government, it has no medical value whatsoever. This is the most restrictive of the schedules. It sits alongside heroin and PCP as a Schedule I drug. But Congress meant for marijuana to be scheduled as Schedule I temporarily. They authorized the creation of a Schaefer Commission to do the first really large-scale governmental investigation into marijuana policies, to the effects of marijuana, and to make recommendations. So there we have the chairman of the commission, which the formal name of the commission is the National Commission on Marijuana and Drug Abuse. And it was a Republican governor from Pennsylvania who chaired the commission. And what they came up with was counter to all of the claims that we'd heard when marijuana became illegal. They actually found that the use of marijuana was not particularly harmful, and they found that there is little proven danger of physical or psychological harm from the experimental or intermittent use of marijuana. They also found that the overwhelming majority of users don't progress to other drugs, and they refuted all of the crazy claims about violence and found that marijuana actually inhibits aggressive impulses. So then they also found that marijuana had not ever been shown to cause anybody to die from a fatal overdose. There were laboratory tests to see what would be a lethal dose in animals, and they administered huge amounts of marijuana, and they could not kill them from a fatal overdose, which is not true, of course, of alcohol or barbiturates. So then the commission came up with its recommendations, and it recommended that there should not be any criminal penalties on possession of marijuana for personal use. Both at the state and federal level, they made this recommendation. A few of the commissioners thought there should be civil fines, but not imprisonment. But most of them thought there just shouldn't be any penalties at all for personal use possession. Of course, as we know, the federal government did not listen. Instead, Nixon went in the direct opposite direction and launched the war on drugs. We've mentioned that marijuana is illegal under federal law, and here we have the current penalties. Any possession is illegal under federal law, as is cultivation is a federal felony, and people face up to 5 years in prison just for growing one plant under federal law. So although the federal government did not listen to the Schaefer Commission and did not have change of heart, we did see some change at the state levels. In the 60s and 70s, there was a large increase in marijuana use among the youth, among middle-class people and upper-class people, and some politicians started to be concerned, and there also started to be a lot of activism for the first time around the issue. Right here in Michigan, a poet, some of you might know, John Sinclair, was sentenced to 10 years in prison for giving 2 joints to an undercover cop. And the state Supreme Court eventually overturned his sentence, and this was a big freedom rally for him, and as you can see, there was just a lot of activism on the issue and to try to lower or eliminate marijuana penalties. So beginning in the 70s, states enacted decriminalization laws. These laws did not go as far as what the Schaefer Commission had recommended. In most cases, they involve a civil fine for people that possess marijuana instead of jail. But 9 of these states' legislatures passed decriminalization in the 70s. One of them, I spoke to the sponsor a couple days ago, Assemblyman Gottfried, who introduced the bill, and he said that the PTA was camped out in his office for about all of 77. It was one of their biggest issues because they were seeing their kids getting arrested and didn't think their lives should be ruined over a joint. So in addition to those 7 states, the Alaska Supreme Court, many of you might not know, marijuana is actually considered legal under state law in Alaska in one's home. The state Supreme Court ruled that possession of marijuana, that under the state constitution's right to privacy, a person shouldn't be prosecuted for possessing a personal use amount of marijuana. And then the other 3 states passed laws since 2000. So as you can see, all regions of the country are represented. A lot of people in these states don't even realize that they have a decriminalization law in the books. Next, I thought we would take a look at what these decriminalization laws do. What they all do is they remove the possibility that somebody could be sentenced to imprisonment, at least for first offense possession of marijuana. In most cases, they replace it with a civil fine. The state's laws vary from about a ½ ounce of marijuana to 3.5 ounces, which is in Ohio. And some of the states, especially the most recent ones, Massachusetts and Connecticut, have a separate penalty for youth. So if someone who is under 18 is caught with marijuana in those states, their parents will be notified, they can discipline them, and they will be sent to drug education and community service. And in most cases, a person will not actually be arrested. Instead, they would be given a citation, much like a traffic ticket, so they don't have to go to court. Jack Cole was the founder of Law Enforcement Against Prohibition, and he likes to say you can get over an addiction, but you can't get over a conviction. So I know we've heard that a lot of people don't end up getting sentenced to prison or jail for marijuana, But even if somebody is arrested and doesn't ever go to jail, they end up with a criminal conviction on their record. And this can cause a person not to be able to get a job. A lot of employers will look at your criminal history. Landlords might deny a person the ability to live in housing. And there are a number of other things that state laws prevent a person from being able to do if they have a conviction. And in some of these cases, these laws only apply to drug offenses. So for example, 10 states say if you have a misdemeanor marijuana conviction, you cannot get food stamps. If you're a rapist or a murderer, that doesn't apply. It's only for drug convictions. And a lot of other states have the same thing for any felony drug conviction. So really a conviction can destroy a person's dreams and their ability to go on with their life, even if they don't ever go to jail. And some of these decriminalization laws, by making it a civil offense, can avoid collateral consequences, at least for simple possession. So now that we have had marijuana illegal in some states for almost a century, and in all states for about 75 years, it hasn't worked. We have 104 million Americans that admit that they have used marijuana, according to surveys. But at the same time, only some of these adults are ever arrested. And so, as was discussed, it's somewhat arbitrary as to who is arrested. But worse than that, as one of the people who was in the audience mentioned last time, it appears to be discriminatory. There was a very good book that was mentioned that Michelle Alexander wrote called The New Jim Crow, and it goes through just staggering statistics and quotes about the disparate enforcement of drug laws at every step of the process. And for one example, African Americans' marijuana use rates is about the same as whites, but they have 3 times the chance of being arrested for simple possession as whites. And meanwhile, of course, there are other people that never get caught and go on to be president or Supreme Court justice without having their dreams derailed. So one of the reasons that's usually put forth for the status quo and for not decriminalizing or not legalizing marijuana is the claim that it will lead more people to using marijuana. And so the National Research Council, I think it was called, took a look at that and looked at the data, mostly comparing the usage rates in decrim states and non-decrim states. And they found there was little apparent relationship between the severity of sanctions prescribed for drug use and the prevalence or frequency of use. So as you can see here, there's a very broad range of use rates within decrim states and within non-decrim states. The state with the highest marijuana use rate is Rhode Island, which does not have a decriminalization law, and the third lowest is Mississippi, which does. So there's no real correlation there. And in addition, in the Netherlands in the 70s, they did their own study, much like the Schaefer Commission, but they actually listened to it. And there, the social scientists had suggested that they break the link between hard drugs and soft drugs and separate the markets. And so they've done that. And marijuana is technically illegal, but people don't get prosecuted for small amounts, and nor do stores that sell small amounts. And there they have lower marijuana use rates than we do here in the United States. And there's also the question that I should mention that people have raised of whether or not it's even necessarily a good public health policy to have a lower marijuana use if people are using alcohol instead, when alcohol is so much more dangerous, when it's associated with sexual assaults and violence, and when you can die from overdoses on alcohol, when you can't from overdoses on marijuana. So here we have a chart of marijuana arrest rates in the United States. Since around when the Schaefer Commission released its report, we have had arrest rates skyrocket. Over 800,000 people are arrested now, or sometimes it may be the same person arrested twice. There are over 800,000 arrests every year now for marijuana, 88% of which are for possession. That's 4 times the rate in 1970. And at the same time, it hasn't stopped people from using marijuana. At that time, 11% of Americans reported they'd ever used marijuana, and now it's 34%, and current use rates are also not down. So on the states that have decriminalized the possession of marijuana, they've seen a lot of savings. They see savings for law enforcement that don't have to spend time booking people and processing cases just for simple possession of marijuana. Also, courts and prosecutors and public defenders don't have to get involved. And also, jail, even if a person isn't actually sentenced to jail, a lot of times they'll spend a few hours or a night or longer in jail after their arrest and before they're released. So Washington State considered a decriminalization bill in 2010, and just to give you the idea that the savings a state can have just by that simple change, Their official state estimate was that $16 million a year would be saved with decriminalization, and almost $1 million would be generated. And Washington has a smaller population than Michigan. It has about 6 million people. So here we are, 40 years after the war on drugs, 75 years after marijuana's been illegal in every state, and marijuana is the leading cash crop in our country. The estimates are there are over $30 billion every single year for the marijuana trade versus about $23 billion for the second runner-up, which is corn. And as I mentioned, more than a third of Americans have used marijuana. At the same time, it's caused an enormous fiscal and human cost. Jeffrey Myron, who's an economist at Harvard, estimated that the combined savings and revenue that we would have annually if we ended prohibition and replaced it with legalization and taxation would be about $20 billion every single year. And my colleague Dan discussed earlier about the people that die because of prohibition. So nobody has ever died from overdosing on marijuana, but there have been people with botched raids where either police get killed or the people who are being raided get killed in some cases. And I think as was touched on earlier too, when you have an illegal market, disputes are usually sometimes resolved with violence. So there are also a number of people that died as a result of that. And there have been some who have died in jail. There was a quadriplegic man in DC that was sentenced to 10 days in jail for possessing a very small amount of marijuana that he said made him feel better. And the judge thought he wasn't remorseful enough since he said it made it feel better, and he didn't get the medical care he needed, so he died 4 days into his sentence. And obviously if he had never been arrested, he would still be alive. So now I'm gonna shift to talk about medical marijuana. Discussed marijuana as a Schedule I drug. So all distribution or possession of marijuana is legal unless it's for a narrow research exception. Throughout the years, there have been 3 ways that marijuana has been considered allowed for research. One of them is the Compassionate Use Program. Another is state research programs that were in the 70s or 80s. And the last one is the kind of clinical trials that are going on now, which are very expensive and very small scale. In the 70s, a man named Robert Randall was living in Washington, D.C., and growing marijuana to treat his glaucoma. He got arrested and prosecuted and raised what's known as the necessity defense, which is available for all kinds of criminal defenses in court. And he proved that even though he committed a crime, marijuana was medically necessary so that he did not go blind. And then he went and he sued the federal government to ask them to let him into a research program, and he won. And starting in '76, the federal government, from its monopoly marijuana farm in Mississippi through his pharmacy, gave him marijuana every month until he passed away. This program was open to additional patients, and it was closed in 1992. So at the peak, there were 34 patients, I believe, that got marijuana every single month from the federal government, and the 4 that are still alive are still getting marijuana from the federal government every single month. And even though it's called an investigational new drug program, of course, the federal government never conducted any studies on any of them. So earlier, one of the other panelists mentioned that there are a lot of state laws on the books that we don't usually talk about. From '78 to '95, 34 states enacted medical marijuana laws, and none of them are protecting anyone right now. Some of them use the word prescribe. Of course, marijuana can't be prescribed because of federal law, and most of them relied on the federal government cooperating. And for a very short amount of time, it did. 7 states had programs that were up and running. They were called research programs, but the purpose was access. So Michigan and a few other states had these programs. However, other ones didn't open up. The federal guidelines for research got much more restrictive, and now that's not something that's happening anywhere because of the change in federal policy. So right now, the only research that's being done is the California research was mentioned. It was funded by the state of California. It cost $9 million. There were only 150 patients that were enrolled in it, and they got marijuana for about a week to be studied, and then they had to not use marijuana beforehand, and they had to use placebo. So it wasn't something that was a way that anybody would actually get access to marijuana. It was really just for research. It's worth noting that there have been, I know there was mention about whether or not there's federal obstruction of research. There have been at least 3 studies where the FDA approved a study, and then NIDA, which is the federal agency in charge of giving the marijuana to researchers, would not give them the marijuana. The most recent was just this summer with a PTSD study that was approved by the FDA, and then the HHS said, we won't give you the marijuana, and they told them that they need to make some changes. And to get approved, they need a unanimous approval from these 5 members of the HHS, 2 of which gave directly contrary advice to what it would need to be. One said you need all the patients not to have used marijuana before, and the other said you need them to all have used marijuana before. So there's certainly still a lot of problems with federal obstacle to research. So since 1996, states have had to find a way, given the federal obstruction and obstinance, to protect patients who are using marijuana and finding relief, or who would if it was allowed under state law. And they've had to do so in a way that would take into account federal law. In 1996, voters in California enacted the first modern medical marijuana law. And what it does is it removes the state's criminal penalties from possession and cultivation for patients and their caregivers. It relies on a doctor's recommendation instead of a prescription. And because 99% of every marijuana arrest is done at the state or local level, even though marijuana possession is illegal federally, it made it almost impossible that an individual patient or caregiver would be arrested or prosecuted in practice. And in practice, the federal government doesn't generally target low-level marijuana users anyways. Since then, 15 other states and Washington, D.C. have followed suit. These laws have a lot of similarities, and they also have some differences. The ways they're similar, as I mentioned, all of them focus on removing the state's own criminal penalties. They also all rely on some kind of medical professional, usually a doctor's recommendation or certification. Most of the states, all of them but Washington, have ID cards, so a patient can send in their doctor's recommendation to the state verifies that recommendation, and then the person gets an ID card so the police officer can know that they're authorized by the program and allowed to use medical marijuana. All of them say that they don't allow a person to work while they're impaired or something along those lines. And of course, none of them would have a doctor, a pharmacy, or the state dispense marijuana, because doing so is a federal crime, and none of those 3 parties are likely to want to commit a federal crime, so it would make the law ineffective. There are also a number of differences between the laws. Some of them are more explicit in the employment protections. Arizona specifically says a person can't be fired for failing a drug test unless they're actually impaired at work, or unless the employer would be in a catch-22 because federal law would require them to be fired in some cases, or disciplined, like for truckers. In addition, they differ in whether or not state patients can qualify. They do in Michigan and a number of the newer states. There's differences in how much marijuana is allowed, how many patients a caregiver can serve. Some have a defense that's available in court if a person doesn't have an ID card. Michigan's one of those. And let's see. Many of the states allow a state health department to add additional qualifying conditions. Michigan's one of those as well, although I think the state hasn't acted on any of the petitions at all and has just ignored them. So the biggest difference between the state laws is how we get marijuana, and I'll get into that a little bit later. First, I thought we'd take a quick look at court decisions related to federal court decisions. One of the 2 U.S. Supreme Court decisions on medical marijuana was U.S. versus Oakland Cannabis Buyers Cooperative. I mentioned the necessity defense earlier. In this case, people who worked at a collective in, I think it was 1998 in Oakland, California, raised the necessity defense in court. I think the federal government was trying to enjoin their operation, and they said, we're preventing a greater evil by making these people's health better. And the court said, whether or not you could prove the elements to this defense, it's just not available to a federal CSA violation for distributing marijuana. So they weren't able to raise it. And I won't discuss Gonzalez versus Raich, because there's been a lot of good conversation about that already, but that picture there is Angel Raich. So the 2 decisions at the Court of Appeals level and the federal level on the issue are Conant versus Walters and Gonzalez versus Raich when it was back on remand. In Conant, the Clinton administration had threatened doctors in California that would recommend medical marijuana. They said they'll take away their ability to prescribe drugs if they make a medical marijuana recommendation. And a doctor, Marcus Conant, sued and went to court and said that he had the First Amendment right to make a recommendation. Not a prescription, a recommendation, and he won. So that's the underpinning of all the state medical marijuana laws, that a doctor has the First Amendment right to recommend medical marijuana. And this quote was shown earlier from Gonzalez versus Raich that found that a person on remand, the Ninth Circuit found that a person does not yet have a fundamental due process right to save their life by using marijuana but that someday, if enough states act with changing values in society, someday there might be. Now, there was also some discussion about Department of Justice policy. There's mention of the Ogden memo. When Obama was running for office, he said he was not going to use federal resources to circumvent state medical marijuana laws. The Attorney General testified in Congress specifically about dispensaries and said the same thing. It wouldn't be an enforcement priority. They wouldn't focus on it. So a formal memo was issued in '09 that was along those lines. And then last year, we've seen a lot of backtracking. U.S. attorneys sent some threatening letters in a number of states, and the Department of Justice issued a new memo, which they claimed was completely consistent with everything they said before, but was much more limited and was limited only to patients and individual caregivers assisting patients. In practice, the Department of Justice has not been rating those dispensaries that are regulated and licensed by a state. And they have sent some threatening letters to a few Colorado dispensaries that are state regulated that are close to schools, but they haven't actually done raids and they haven't had full-scale actions. And then the Attorney General was again questioned by the same Congress member from Colorado, and he again tried to make it sound like, no, it won't be an enforcement policy priority. They were talking about dispensaries, I believe. If a person is complying with a state law, it's not a priority. So it's a bit muddled, just put it mildly. So looking back to the state laws, states have two ways that they've provided people with access to marijuana, other than getting it from the illegal criminal market. And one of the models that states have is allowing the home cultivation by patients or caregivers. And for some patients, this is a good means of access. If a person has a long-term illness, it can be very therapeutic. Insurance does not cover marijuana, so it could be very expensive if they have to go somewhere else to obtain it. And it has the advantage that the federal government hasn't been focusing on individual patients and caregivers ever, so there's less of problems with federal interference. However, there are some shortcomings. Some patients can't find a trusted person willing to commit a federal felony for them and that can do a good job at it. I know that I have managed to kill 2 cactuses now, so if my health was dependent on my botany skills, I would be in big trouble. Some people have landlords that say that they can't grow marijuana or that they don't even have the space to grow marijuana. So there are a lot of reasons why this might not be a sufficient solution for people. And it takes 4 months to get from planting a seed to producing usable marijuana. So no other prescription would you have to wait 4 months to be able to fill, and it doesn't make sense that patients would have to wait that long. So even for patients that can grow, it would be good for them to have the dispensaries available in case they have a crop failure or in case while they wait for the 4 months after planting a seed. So some states now have allowed dispensaries. California's law is a little bit vague on this. They explicitly allowed collectives and cooperatives, but a county attorney says that sales and storefronts aren't allowed. Nonetheless, a lot of cities have regulated and allowed dispensaries. So California was the first state kind of in 2004 to almost explicitly allow dispensaries. And other than that, all of the states that actually licensed or regulated dispensaries, and California does not have state licenses for dispensaries, but all the states that have state licenses were after the Obama administration, after he'd made the more reassuring comments about federal policy. And this is better for public health, to have regulated dispensaries, to have them have lab testing perhaps, and have security requirements is something that communities tend to be more comfortable with than if everything was underground and unregulated. And ironically, the federal policy, the more crackdowns you have, the more it's going to be diffuse and unregulated, as Dan mentioned, that the Controlled Substance Act being used to prevent control of substances would be absurd. And some states allow both, which is the best option for patients. So here's a map. You can see all the blue states, the laws explicitly allow cultivation and caregivers and don't mention dispensaries. The green ones, which are small states, New Jersey, Delaware, and the non-state of DC, only allow dispensaries, and the red states explicitly allow both dispensaries and home cultivation. The dispensary states are all pretty new, the dispensary-only states, but they're not up and running yet. So patients in New Jersey have been waiting 2 years to have any kind of legal protection or access. They hopefully will later this year, but for some patients, they might not even be alive anymore. So now we'll look at the 3 states where they have dispensary laws on the books and where they're already up and running. Colorado had a law that allowed for patients and caregivers and didn't mention dispensaries. Caregivers could and did serve unlimited people, so there came to be dispensaries. They just weren't mentioned or regulated under state law. So in 2010, the state legislature decided to put some rules in place and explicitly allow dispensaries. It required dispensaries to all pay a fee and to get a local license, and then they had about a year where the state came up with some regulations, which some people think are too onerous and are fairly onerous, and then the dispensaries had to get a state license. So there's video monitoring, there's these little radio frequency tags on every single plant, and localities can choose if they want to allow dispensaries or not, and some have decided to allow it and others haven't. This has brought in a substantial amount of money for the state. The fees alone brought in almost $9 million in 1 year. And taxes, we have numbers from some cities, but not all, but in 2010, there was at least $6 million in state, just normal sales tax revenue at the state and local level. All right. And speaking of income, I don't have a slide for California, but I'll mention that in California, the state brought in between $50 and $105 million just on sales tax from medical marijuana dispensaries in 1 year. So now New Mexico was the first state after the Obama administration had come into power that explicitly allowed producers. They have 23 producers now. They can grow up to 150 plants. There were some problems with them not being enough supply since they had a small plant count, but they allowed more producers since then, so it seems to be okay. There, they all have to be nonprofits. In Colorado, they can be for-profit, like a pharmacy can and other businesses can. But in New Mexico, there's a competitive application process. So the state will look at the application, they'll look at the training plans that they have, security plans. All of the entities have to have patients and a doctor on their board, and then they'll decide which ones to allow to operate. Like the other states, the fees that are paid by dispensaries cover the cost of administering the program. The last state with a dispensary law that's already up and running is Maine. Voters approved Maine's medical marijuana law in 1999, and they added on dispensaries in 2009. The health department was efficient in getting it up and running, and in 2010, they had issued 8 different permits for dispensaries, and 6 of those are up and running now, with 2 more expected to be up and running. There, they also are only nonprofit, and they also had a competitive licensing process where they looked at security plans and things like that. There have been a number of supportive comments from police chiefs or mayors saying that they don't see these as a problem, they don't have any community concerns, that they're operating well. And of course, there are a number of regulations for security, oversight, that kind of thing. They have to have lighting outside and some electronic monitoring. All right. Finally, we'll discuss what to expect this year and beyond. So polls have shown between 60 and 80% public support for medical marijuana nationwide, and that's been consistent. So there's no question that states are going to continue enacting medical marijuana laws in the future. But right now, there are 17 states that have bills to create new laws that are being considered by state legislatures. In addition, on the 2012 ballot, we will probably have 3 states, perhaps more, that will vote on medical marijuana. Massachusetts, they've already finished the first wave of the signature drive. I think Arkansas and North Dakota are also likely to, and I know there are attempts in Ohio to qualify initiative 2. In addition, in the states with existing laws, we'll see legislation introduced and considered to change the existing law. Hawaii and Washington State are considering adding dispensaries, and I think in Michigan, right now, there are a number of very bad bills that would destroy the law that voters enacted that are being proposed, but they would need 3/4 supermajority to pass, so hopefully they will not. There could be a majority of states that have medical marijuana laws in the books by the end of 2014. This map shows ones in green that have had state legislation for a number of years and where there's a strong reason to believe they could pass in the near future, and the red states are ones that I mentioned that might vote on initiatives this year or ones that are expected to vote in 2014. This would be 47% of the American population that would live in a medical marijuana state. Right now, it's 30% of the US population lives in a state with a effective medical marijuana law. So there are also going to continue to be efforts to change federal law and federal policy. Ways federal policy can change is the president can deprioritize enforcement, as we've discussed. Congress can change laws. There's a bill that's pending now that would remove penalties from people who are in compliance with state laws. Eventually, hopefully that will pass. We discussed the language in Race 2 that someday there might be a due process right to use marijuana to preserve one's life or maybe health. And then there's been discussion also about rescheduling petitions, which 4 governors have now signed on to a new petition, and medical evidence continues to accumulate about the medical efficacy of marijuana. So eventually one of those could be granted. In addition, states will continue to look at removing at least their criminal penalties from possession of marijuana. Those 9 states all have bills pending to impose a civil fine for possession of marijuana. Rhode Island and Vermont are both very likely to pass their bills within the next year or 2. And those both would provide for a $150 fine for up to an ounce of marijuana. In addition, for the first time, we might see a state this year end prohibition within the state and allow possession and some kind of access to marijuana. Signatures have been handed in both Washington State and Colorado, and there are signature drives in process in 4 other states, including Michigan. Thought we'd take a quick look at the 2 that have already had signatures handed in. Washington State's measure, like the way alcohol is treated, would allow adults 21 and older to use marijuana under state law, and they could possess up to an ounce. It would also allow for marijuana-only sales, and I think official fiscal estimate is it would generate $215 million every year if, of course, if the federal government did not go shut down the stores. Interestingly, even though this initiative has not even actually qualified for the ballot yet, it's had a lot of prominent law enforcement supporters and other prominent supporters. 2 former U.S. attorneys for Washington State, for the Western District of Washington, have endorsed it. The former FBI agent in charge of Seattle has endorsed it. The former head of the State Bar Association and the current city attorney. The other state where voters are almost sure to vote on this issue in 2012 is Colorado. And that initiative would also apply to adults 21 and up. That one would allow home cultivation of up to 6 plants, like people can brew their own alcohol or beer. They'd have to be in a locked location, and it would allow retailers and wholesalers, and it would also provide for licensed testing facilities, which they have in Colorado and some other states for medical marijuana. And there'd be excise tax. I know Dan mentioned that earlier. Here, a lot of the messaging of the campaign, I think, may focus on comparing marijuana to alcohol. The people involved in the campaign were involved in a couple of earlier campaigns that focused on the fact that marijuana is a safer alternative to alcohol since it's not linked to violence and it's not deadly. Polling indicates these both have a very real chance of passing. Some polls have shown plurality support and some have shown majority support. And there are also 4 states with initiative drives that are in progress, including Michigan. Since we're in Michigan, there's Matt Abel has the petition there. And this is the full text of the amendment that's proposed. It would be a constitutional amendment. I need 323 valid signatures by early July 2012. And I'm sure if you want to volunteer to help with that, there are people here you can talk to. And it would apply to people 21 and older as well. So finally, the federal policy for non-medical marijuana. Dan mentioned this bill earlier. For the first time ever, last year, a member of Congress introduced a bill that would take away marijuana out of the Controlled Substances Act and that would remove the criminal penalties at the federal level for marijuana. The only thing that would be illegal would be transporting marijuana from a state that allows it to one that doesn't allow it. It was sponsored by Barney Frank and 20 co-sponsors. So compared to the 435 members of the House of Representatives, 20 is not that many, but compared to the 0 people that have ever sponsored anything like this before last year, it's very rapid progress and is an exciting sign of what's coming. Here we have Gallup polls on whether or not Americans think the use of marijuana should be legal. Back in 1970, only 12% said yes. In 1996, 25%. And now, for the first time ever in 2011, 50% of Americans thought that marijuana use should be legal, which is more than those that thought it should be illegal. Just as marijuana prohibition began with state laws decades ago, and the federal government followed closely behind, we're now seeing the same process in reverse. As the public is increasingly rejecting prohibition, states are going to begin to pass laws to make marijuana use and sales legal. And it seems like it's only a matter of time before the federal government sees the light and follows suit. And that's it for me, and I'm up for taking any questions anyone has. not sure, but I think that now that we have 50% public support, once there starts to be a critical mass and it looks like this is something the public's behind and that could really happen, we might see a change. There are all kinds of supporters of changing policy that are just starting to speak out now that hadn't previously. The California Medical Association came out in favor of making marijuana legal last year. The NAACP from California supported it. So I wouldn't be surprised if we see, perhaps they would consider it a business opportunity in the future. We've actually had a couple calls at MPP where I work from people from pharmaceutical companies that were wondering about state laws and that were interested. So it might be a matter of time. Sure.
You don't list Maryland as a medical marijuana state.
Uh-huh.
And I know from a little work I'm doing that it's sort of a 2/3 medical marijuana state. Maybe you can talk about that
Sure.
a little bit.
So patients who are in Maryland are worse off than patients who are in Massachusetts, which has no medical marijuana law. Oh, now they're in some ways worse off, some ways better off. There's no means of access. So our test for if we count a state as a medical marijuana state is if it allows either cultivation or distribution. Maryland's law says that if you get arrested for marijuana, you can go into court and raise a defense. If you prove that defense, you'll be acquitted, but you still have to go to court and you still have to prove it. And you also have no means of access. So until last year, you also had to pay a $100 fine. So at that point, you were better off in Massachusetts, where you also have to pay a $100 fine, but don't have to first prove some kind of defense. So it's some organizations will count it as a medical marijuana state, and some don't. But we figure since there's no access and because it's affirmative defense, we don't list it.
Isn't that effectually the state of affairs in Michigan because of the courts?
Well, in Michigan, the law says you shouldn't be arrested if you have an ID card and a certain number of plants. So under Michigan law, a patient should be able to grow up to 12 plants or more and possibly to raise a defense, and they shouldn't be arrested for possession. Yes, Gersh?
There's a pretty good blatant refusal of the state to honor the law.
Yeah. So this is what the laws are. What they are in practice, unfortunately. I know I've been illegally arrested at a protest myself, so unfortunately, they're not always implemented as they should be.
And you said that nobody that's died from an overdose of marijuana, and I agree with that. The same thing really applies to the LSD. But my point is that there's a behavioral that can come from drugs like marijuana that results in behavioral toxicity. One of my major concerns is the impaired driving, because that's why, and I'm sort of not talking about the medical aspect of it, but the other uses of it, that it is used, in fact, to induce changes in the central nervous system. So do you have a comment on that?
Sure. Yeah, with any substance, there's dangers if people drive under the influence of a substance. With marijuana, interestingly, some studies, and I certainly think nobody should drive under the influence of marijuana. People are impaired when they do, and that's dangerous. But it's interesting that if you compare the relative harms, risks of driving under the influence of marijuana and alcohol, studies have indicated that people don't appreciate the risks. They are much more risk-taking when they drive under the influence of alcohol. So, for example, they'll speed and things like that. And people who are under the influence of marijuana, while they do have impaired reaction times, are very aware of it. So if they're foolish enough to drive, they often will drive like 20 miles an hour. So if they hit somebody, it's not as dangerous. And still, nobody should do it. But if we're we're a society where we've said, we're going to make some drugs legally available, prescription drugs and alcohol, in comparison, marijuana isn't as big of a risk.
Follow-up to that, I recall a case in the Michigan courts within the last few years where a driver who had used marijuana legally in Europe returned, a truck driver, returned to his job days later because apparently THC can remain in the bloodstream for very long periods of time. He was cited and lost his job and some other things. And I think that made its way up through the courts, and the Michigan Supreme Court was very unsympathetic to his argument that he used marijuana legally and was not impaired.
Yeah, so in some states, it's a crime to drive with even metabolites in your system. And marijuana metabolites, which is what the body produces after somebody consumes marijuana, they can stay in your system for weeks. THC itself can also stay in the system a long time, but it's more like a week at most for people that use it frequently. But for a patient, they're going to always have some THC in their system for a lot of patients because it stays, the more marijuana somebody uses, usually the longer it might stay in their system. In Michigan law, there is a zero tolerance law for driving under the influence of any Schedule I drug, and marijuana is currently Schedule I in Michigan. And so, some courts have ruled, initially the courts here ruled that if you have metabolites in your system, that's considered driving under the influence, and not only could somebody be fired, but they could be convicted even if they're completely sober. They can prove they're completely sober, they still could be convicted. More recently, the state Supreme Court overturned that, but they still said THC in one's system was per se. Even if you're completely legal, you can prove sober, and you can prove you're unimpaired, it didn't matter. And so now there's some issues being litigated with medical marijuana patients because the law says that nobody can be subject to any penalty or prosecuted for use of marijuana and for internal possession of marijuana, having it in their system. So we would intend for them not to be able to be convicted if they're driving sober. It does say you can be, convicted for driving under the influence of marijuana, but that would be if somebody's actually impaired. So there are a couple of court cases on that issue. But for non-patients, if they have any THC in their system, there's no question that they could be subject. Well, actually, I think Neil litigated one case where he raised an equal protection argument. So one district court judge has ruled otherwise.
We had a case in Troy that I defended somebody on who was not a patient at the time. And we raised an equal protection argument. The judge ruled that the passage of the Medical Marijuana Act was killed by implication. Michigan's schedule of marijuana is Schedule I drug. Judge Kirsten Nielsen Hardy in Troy. That case is covered.
We've had one more question.
Okay.
Okay, since it is a Schedule I drug, the government's telling me that the National Cancer Institute tells me that it does fight cancer and that anti-tumor effects. The other Justice Department is saying it's a Schedule I, it has no medical. How many states is it going to take for the government to be able, for the United States to tell the federal government that it is not a Schedule I drug? Is there a formula?
There's no magic number, but I think the more states we have it, eventually the federal government, whether it's Congress or whether it's the HHS, when they consider a rescheduling petition, will certainly have to listen. Interestingly, the DEA's own administrative law judge ruled on a rescheduling petition back in 1988, and he found that marijuana was one of the safest therapeutic substances around, and that it was arbitrary and capricious for the DEA to stand between suffering patients and marijuana. But then a political appointee overruled him, and the court said they can overrule him. They don't have to actually, listen to the man that considered all the scientific evidence. So thank you so much, everyone.